I'll recognize a ranking member for 7 minutes.
Thank you, Mr. Chairman. And if there are other members who would like to speak, if you'll kindly let someone know, I'll adjust my time. Let's come back to Dodd-Frank versus bankruptcy, because that's what this has become about today. Let's ask this question. What is it that you find that you can do with bankruptcy that you cannot do with Dodd-Frank?
The advantage of bankruptcy...
Can you pull your microphone closer, please?
The advantage of the bankruptcy is it is part of our system for creditors. It's been around. It's part of the rule of law. It can work for all kinds.
I understand,
of firms,
and
that's what you want to do.
Time is of the essence.
And then
I may
what
have
you
to
want to
move
do
on.
is make it available.
Can you give me something that you can do under bankruptcy that you can't do under Dodd-Frank?
Yeah, well, that's the main thing. You have the rule of law applies, and in Dodd-Frank you don't.
Dodd-Frank is not the rule of law.
The Dodd-Frank has tremendous discretion, authority given to the FDIC.
But that's under the rule of law.
How they treat creditors.
Let me go on to Mr. Kriminger. Mr. Kriminger, can you tell me something about Dodd-Frank that allows it to do what we, generally speaking, want to do with bankruptcy, please?
Well, essentially what Dodd-Frank does, I said, is really supposed to be an alternative. And I worked a long time working with a number of people in the bankruptcy bar to try, when I was at the FDIC, to try to make sure that Title II would not be viewed as being substantially or substantively different in the way it would treat creditors. Yes, there is more discretion, but the discretion is inherent to the ability to address a systemic risk. And I think if we go and say we have to eliminate the discretion, we're eliminating the ability to deal with a systemic risk in a crisis. So clearly Title II will allow you to do that. It's also simply not true to say that Title II does not or ignores the rule of law. Title II just has the rule of law after the decision is made initially, and you can file suit for damages. Under U.S. law, it's always been viewed as being an appropriate remedy to be able to file a suit for damages rather than having a judge make every decision in advance. That is the bankruptcy way, and bankruptcy should apply wherever possible.
Let's talk for just a moment about bridge institutions. There seems to be this notion that a bridge institution is somehow going to come into existence, reap a lot of benefits, a lot of money is going to be made. What is the purpose of the bridge institution? And talk about its longevity, please, Mr. Kriminger.
Well, the bridge institution is designed to be a very short-term entity. I think much of the discussion today about the length of a bridge company being up to 5 years, well, that's also true under the FDI Act, and the average length of time for a bridge institution under the FDI Act has been less than 6 months. Now, it might be longer under a Title II situation, but remember, under the single point of entry approach the FDIC is talking about, you would be taking over the holding company, which is a very simple organization. The way they plan to do that would be to do that debt for equity swap, if you will, a creditor claim for equity swap for the debt within 6 to 9 months, because I'll assure you that the FDIC does not want to run a mega institution for any extended period of time.
Mr. Kriminger, in your paper you also talk about time being the enemy in a time of crisis. In 2008 it was a time of crisis and time was the enemy. Would you please elaborate on time being the enemy and juxtapose this to bankruptcy as an option?
Well, I think time is an enemy because you need to act very quickly. In 2008, on the weekends when things need to be done, and that seemed to happen on far too frequent a basis, you had to make the decisions and come to a conclusion about how to deal with an institution by the Sunday night before the business opened in Asia, because once the markets opened, it would be too late and the illiquid institution would fail. If you look at the Lehman bankruptcy, and again, I would like to see bankruptcy improve where it could deal with this situation much better. But if you look at the Lehman bankruptcy itself, it effectively allowed for a transfer of the broker-dealer in that case by keeping the broker-dealer open with large funding from the Federal Reserve Bank of New York. We want to get to a situation where an institution can be closed and can be resolved while losses are imposed, rather than having funding for an extended period of time so that some creditors get out and complete their transactions. I think the Lehman bankruptcy illustrated some of the issues with bankruptcy and illustrated some of the ways forward on how we can make improvements.
We understand that banks don't go through bankruptcy, generally speaking. They go through a process with the FDIC. Is what we are attempting to do with Dodd-Frank, which by the way is in its infancy, it's still being developed, rules are still being promulgated, is what we are trying to do with Dodd-Frank similar to what is being done with FDIC and banks, generally speaking?
It's based upon essentially the similar powers. The FDIC, I think, as I was saying in my testimony earlier, that's been internationally recognized. You need to have certain powers in extremis, if you will, to be able to take those actions. So it's really based upon the same models of authority to take action and then have a determination.
Now, there were some points that you wanted to make earlier, and I remember you didn't get an opportunity to. If you made notes of them, I'd like for you to use some of this time to make those points.
Well, I would just note, as I was trying to make, well, I just note in response to some of the questions earlier that clearly some of the improvements we're trying to make to the bankruptcy code in order the ability to act more quickly, the first day order issue, the ability to find an identifiable area of cash for debtor possession financing and others, the ability to deal with systemic risk. In fact, the creation through potentially a Section 343 sale under the bankruptcy code of a sale to an entity that would be similar to a bridge company is very much modeled upon we're talking about in Title II. So I think we just have to keep in mind that the changes we want to make should be appropriate for the types of entities we're talking about, and I don't think we'd want to have all those changes in the normal bankruptcy process anyway. So we need to make sure that in the changes to the bankruptcy code we make it more effective, but not dramatically change the normal bankruptcy process.
Is it possible for bankruptcy itself to have an adverse impact upon the economy in a time of crisis? For example, if AIG had gone through bankruptcy in a time of crisis, how would that have impacted the economy?
Well, I don't want to really speak to AIG particularly, but being it's an open company at this point, but certainly I think that if you had the rapid deleveraging of a company that's involved very much in the derivatives markets, that could be very destabilizing in the marketplace. And one of the great things about the ability to terminate net contracts in bankruptcy or under the FDI Act after a one-day stay is that it allows people to have liquidity in their market contracts. One of the bad things is that if you have that ability to immediately terminate those contracts and dump them on an already illiquid market, you run the risk of having much more illiquidity in the market and it frees up in the markets.
Thank you. My time has expired. Thank you, Mr. Chairman.
With that,